applicant who is not, as they were to say, a rookie. He is someone who has been involved in other equally serious offenses. He is tried for these offenses. He's convicted for these offenses. There's then a second trial process in front of the High Court where he is tried and he is, in fact, there convicted as well. But this trial takes a somewhat unusual path. And it takes an unusual path in the sense in which there's no direct evidence against him. There is the application of a very particular doctrine, one of recent possession. And it is applied in a very particular manner, and an unusual manner, not to a weapon, or rather not to an item that is stolen in the context of the commission of this offense, but more particularly in respect of the actual murder weapon itself. And then there are a vast array of inferences that are drawn from that, and conclusions that are drawn and built on the logical foundation of that. Now, Deputy Chief Justices, the center point of the application is that there are a number of challenges, firstly with the very notion of the application of the doctrine of recent possession in three respects. Firstly, in respect of the manner in which the weapon itself is identified, whether that is in fact even established in the first instance. Secondly, leaving aside the issue of whether it's been correctly identified, the manner in which the doctrine itself has been developed. And then, of course, thirdly, the question of whether, having built it on the foundation of the doctrine alone, with no other evidence, in circumstances where there are no other witnesses, one can then draw conclusions about the elements of the particular offenses and whether there are inferences that can be drawn from that. So that, in essence, is the thrust in which the application is going to take. But of course, before one even gets to the questions of the substantive merits, there's one very, or rather two questions that loom very large. Firstly is the question of the lengthy period of time. Now, Justices, if one were to look at the objective timelines in the condonation application, or rather, one would see that you have an offense that is committed in 2006. You have a conviction that is recorded and finally done in June of 2009. There's then a leave to appeal. That leave to appeal process is processed in September of 2010. That leave to appeal is largely unsuccessful, bar for one aspect, which is to allow the applicant to canvass questions about whether there is one or two armed robberies in the context of in the context of these offenses. It's not a ground of appeal, or rather an issue in the leave to appeal that is going to fundamentally affect the overall sentence. It's one that is going to affect only really the technical question of the number of offenses. There's then a considerable period of time. In the portion of this period of time, the applicant is then advised that, well, actually pursue a petition before the Supreme Court of Appeal. Lengthy periods of time go beyond that. That is finally prosecuted in 2017. The Supreme Court of Appeal accepts the explanations insofar as for the delays, allows for the application to be heard, but summarily dismisses it on the basis that there are no reasonable prospects of success, and there's really no other questions of law that important questions of law that need to be addressed. That's in 2017. We then are dealing with a leave to appeal application that is launched for the first time 5 years, 9 months later, before this court. It's one that comes without an application for condonation. That application for condonation is a separate application that only comes 6 years and 3 months after the passage of time. So you have, and that application for condonation, I will be the first to admit, if it's a 3-pager. It's not one that in any meaningful way addresses any of the concerns that this court would have in an application of such a nature. Now, Deputy Chief Justices, I would be the first to admit that those facts alone in normal circumstances would be entirely dispository of any appeal. You've taken 6 years to effect an appeal. You don't have even the most basic reasons on paper as to why you have taken this length of time. That doesn't appear to be, or that would not be the type of matter that one would consider under normal circumstances to be worthy of the attention of this court. But Deputy Chief Justices, when one then looks at the particular circumstances of who this applicant is, I would submit that there's a different color to be drawn in some of these issues. Firstly, we're not talking about somebody who's litigating from a position of freedom. You're dealing with somebody who's litigating from behind bars. You're dealing with somebody who's litigating and has in fact been behind bars consistently since 2006. He's been incarcerated from the 11th of May of this year for 20 years. So he's navigating these waters for 20 years. He's, in the main trial proceedings, managed to obtain the assistance of the Legal Aid Board. Obviously, he's been convicted in one trial and quit, and in others. They've taken the view that, well, I mean, they've assisted him sufficiently. He's assisted by his relatives, and his mother in particular, to advance his case. They are periodically able to fund it, others they're not. Some of the legal teams who represent him do so on a purely discretionary basis. They then take it to the Supreme Court of Appeal, and they lose again. Now, at this point, he has no assistance from the Legal Aid Board. He has his mother, who is the only person who is driving, or at least providing him with some assistance. She herself begins to have health considerations. He has to divert resources entirely in that direction. She ultimately succumbs to her illnesses in 2021. His only other male relative is not someone who's able to assist him in any meaningful way. Quite understandably, given the nature of his offenses, most of his family members drift away. He's convicted of multiple offenses. They are serious offenses. They're not assisting him. He essentially has to navigate these waters alone. And he's not navigating easy waters. He's navigating very treacherous waters, because the legal points he has to address are not the run-of-the-mill, well, it's somebody stabbed somebody else and it's a whodunit. This is a matter in which he's going to have to deal with complex questions of procedure. How has a high court judge dealt with Section 186 and Section 167 under the Criminal Procedure Act? Have they correctly applied those principles within the means of discretion? Have they attended to determining the identity of the weapon? Have they satisfied themselves that that is indeed the case? That's a complex question all by itself. And as your Deputy Chief Justice, Justices, you would have noticed, a significant portion of the heads is dedicated to that. And these are not straightforward questions. They're complex questions. Then on top of that, because the foundation of the doctrine of recent possession is this complicated exercise of how you have ultimately arrived at the identity of a weapon. Then, having arrived at the identity of a weapon, you are still applying the doctrine of recent possession in a completely novel way of doing so. You're building on multiple inferences around it. So, again, Deputy Chief Justice, this court invited submissions specifically on that very issue, to the point of even having to appoint amici to produce that. And their heads of argument are 36 pages on that. These are not the types of questions that an ordinary layman would be able to navigate with any degree of understanding of the principles that that underlie it. Equally importantly is that you can't be raising factual issues here purely. You have to be dealing with the legal implication of those factual questions. Now, Deputy Justice, for every single practitioner who comes to even any court, let alone a court of this nature, it is an enormously daunting exercise. You have sleepless nights, you spend hours and hours on a single case, you are in weeks in the library. Even when you are here, you are extremely nervous. It is just extremely nerve-wracking It is an incredibly difficult exercise to go through the mechanics of navigating your way through what the trial court has decided, navigating your way through what the correct legal and constitutional principles to be applied to that are, and then formulating submissions that even put you in the jurisdiction of this honorable court, let alone the types and substantive submissions that are going to be weighty and considered. Now, that is the background against which he has had to rely on essentially jailhouse advice. He's had to take pieces and fragments from individual prisoners that he happens to come into, say, well, maybe there's this particular option available to you. And there's a very particularly important portion of the condonation application, justices, and it was not framed in a way to be facetious, is that people are not aware that this court is approachable. And it is something quite unique to our jurisprudence, that somebody who is sitting in a jail somewhere, has no lawyers representing them, doesn't really meaningfully understand the principles, can craft something, forward it to the registrar of this court, having lost a lengthy trial at the High Court, having lost an application at the Supreme Court of Appeal, and produce papers that do not meaningfully address any issue, but somehow, somewhere, this is one court that is still, even in the midst of that, going to still entertain him. That there's something there, to the point of even inviting people to file amicus briefs on his behalf. Deputy Chief Justice, Justices, I would go so far as to say this is probably the most unique appeal court out there. The notion that the US Supreme Court would entertain a layman with papers of this nature, that the House of Lords or the Supreme Court of the UK would even be remotely interested in entertaining him, that is almost incomprehensible. Yet this court exists to vindicate the very foundational aspects of the Constitution. And in his affidavit, he says, I'm not even aware of this. I become aware of this. I'm thinking I've lost at the High Court, I've lost at the Supreme Court completely. It's the end of the line. Suddenly, I'm told, well, you know what, maybe put some papers together and try your luck at the Constitutional Court. Somebody might bite. Somebody might give you an opportunity. And he does that. He navigates his way through some of these processes. You look through his submissions, most of them aren't really making much sense. Many of them are addressing irrelevant legal principles. But he puts together something sufficient that in the essence of it has caused at least some of the justices to say, there's something here, let's take a closer look. Those are jailhouse efforts of somebody who has been incarcerated for the last 20 years. And that's the context in which we should view this condonation application. This is not the condonation application of somebody who sat and been tardy and has nothing to do. This is somebody who is in the midst of all of that, somehow, from Groenpunt Correctional Facility, found his way here to Braamfontein in the highest court of the land. And then we look at what he's actually raising. Because even if the time lag and the time that he has taken to get here is dismayingly long, there is still that very distinct question of there has been a very intricate use of the Section 186 and 167 procedure to get us here, which has to be looked at in a sense of there does appear to be, not even appear to be, a very distinct sense of a judge entering the arena and driving a prosecution, and in fact resuscitating what was ultimately and would have in fact even been a failed prosecution, but for that intervention. And the circumstances under which that took place must be tested. And then building on that, you've developed the doctrine of recent possession in a very, very unique and novel way. Now, we would submit, Deputy Chief Justices, that even if this court is minded to say, well, there's just been such a terrible delay, there should nevertheless be an understanding of the foundational questions that he's raising are the types of questions that must be answered. We need to know whether you can use the 186 procedure and the 167 procedure in this manner to arrive at these particular conclusions. We need to know whether you can actually advance the doctrine of recent possession without alerting anyone to it in advance, not to any item that is stolen in the actual commission of the offense, but to the actual murder weapon itself. And we need to know, having built on that, you are going to place someone at the scene, you're going to draw inferences about what that person is doing at the scene, you are going to convict that person beyond any reasonable doubt about what they're doing at the scene, and the only thing that ties him to that is a weapon whose identity you haven't really fully established as to whether it's a 7.65 millimeter on one scene or it's a 9 millimeter on another. You've arrived at that using an unusual procedure under the Criminal Procedure Act, or rather one that has particular obligations. And on top of that, you've then developed this process, or rather this principle, onto a very unusual area of the law. Now, I would submit in that regard that if we have the totality of those facts, we look at the totality of who he is and where he is litigating from, and we look at the type of issues that he's raising, I would submit that this is one of those instances where, even if this court is very aggrieved with the length of time that he has taken to advance these arguments, they are of such a nature that they must be answered and should be considered carefully, notwithstanding the passage of time, and notwithstanding that he may have a less than perfect explanation for the amount of time that he has taken to advance these particular arguments. Now, your Lordships would have, Justice, Deputy Chief Justice, and Justices, you would have noted, of course, that we also at length have gone through the question of the discussion on the leave to appeal principles, and why, leaving aside the question of condonation, this is the type and nature of matter that leave to appeal should indeed itself be granted. Because it raises fundamental constitutional questions, not about the nuts and bolts of the facts of what took place in the High Court. That, Madam Justice Satchwell, dealt with the nuts and bolts of that. But it's the procedural mechanics that she used to get to that, it's the conclusions that she drew from that, and it's the manner in which the law was applied to those particular principles that we submit raise foundational constitutional questions around whether you've in fact had a fair trial. You've had to deal with the novel development of the doctrine of recent possession. You've had to deal with a very distinct and direct intervention of the court under Section 186 and 167 of the Criminal Procedure Act. That, but for that, you would have been acquitted, certainly. We shouldn't even beat about the bush around that. But for that intervention, we would not be talking about convictions in this matter. And then you have used that to draw inferences based on your own very unusual development of the law. We would submit that that raises profound questions, not only in terms of the constitutional questions, but it also raises questions around the arguable points of law within the meaning of the Paulson judgment, which is that you are raising questions on which it is entirely reasonable that another court would not accept that you should have used the 186 and 167 procedure in that manner, would it not accept that you could have drawn the conclusions that you would have wanted to draw, and more importantly, would not have accepted that the doctrine can be built on that particular type of a foundation. Now, we would submit under those circumstances that both the condonation application and the leave to appeal application should be successful in that regard. Which then, of course, brings us to the substantive questions of his submissions. Now, in the last occasion that we were before this court, there was, of course, the correct note made that a number of the aspects of the doctrine of recent possession are dealt with by the amicus. And of course, we have indicated our own position in that regard, and we align ourselves, insofar as the applicant is concerned, fully with those submissions. There are, of course, particular aspects around that that we have raised. But what is centered, the starting point of the submission, and I want to use my remaining time, protected time that is, just to develop this particular aspect, is before we even get to the doctrine and the development of, or rather of recent possession, is possession. How have we arrived at the question of possession? Now, here's how we've arrived at the question of possession. You have a witness who has found a weapon in the possession of the applicant on the 11th of May 2006, records that as a 7.65 millimeter caliber firearm. 3 years later, in the witness box, he's giving that same evidence. It's a 7.65 millimeter caliber firearm that I'm finding in his possession. The state calls another witness. This witness comes to court and says, no, the murder weapon is a 9 millimeter. This 9 millimeter firearm is used, is definitely linked here to this particular murder. It's common cause that the murder weapon on the 28th of April 2006 is a 9 millimeter firearm. Now, logically, there's a problem. How can the 7.65 in one be the same weapon in the other, and then be used as the basis of establishing that the applicant is in possession of this firearm? The trial court correctly castigates the prosecutor around this issue, asks him about questions of, have you established your chain of custody properly? Have you done all of these things correctly? He says, no, I'm fine. I believe I've done what I can. Where the intervention emerges from is not from, all right, I need to clear this up. It in fact emerges from a completely different accused. And a completely different accused in his closing argument, not in evidence, in his closing argument, starts talking about documents that have not been presented in the trial proceedings, starts talking about evidence in those documents and submissions around it that he himself has not laid on. Now, leaving aside that serious questions about whether that should even have been allowed or admitted, those are issues that that particular witness is canvassing. And the trial judge then says, well, okay, I'm concerned about these allegations. Particularly, they might suggest that there's some nefarious conduct on behalf of the police services. Let me then investigate what that is. Delves into that particular process. To investigate that, not to clarify what is the issues around the possession of the third, or rather of the applicant, of the weapon. And I say that in very distinctly, because the record is the rationale for intervention is to clarify the issue of accused number one. It's not to gain clarity about the facts particular to the applicant. And what is the consequence of that? Is that certain witnesses are identified as being essential. That, no, we need this witness for the just decision of this matter. The court themselves identify who those witnesses are, and then doesn't call them. They identify multiple witnesses who say are essential for the just determination of this, calls only two of those witnesses and then leaves it. Doesn't call any witness about the second crime scene, doesn't call any witness pertaining to the chain of custody. Now, the intervention of a court under Section 186 and 167 is predicated on two things. One, it is a discretionary aspect that a court has to do, but it is one that has to be exercised judicially and, most importantly, reasonably. But there's a second component, and that was the aspect that was particularly dealt with in the Masowa judgment, is that The other aspect of it is the one that's conveniently left out, or rather often not focused on, which is that having elected as a court to exercise your discretion to, in fact, clarify certain issues, if there are other issues that arise that are necessary for the determination of this matter, you are then obliged to call for those witnesses. And if you fail to call for those witnesses, that is an irregularity all by itself. And here's the rationale for that. It is that once you've opened up a Pandora's box, and if you're the one who opens up that Pandora's box, you then have to answer all of those questions. You cannot open up a matter to clarify something. 5 other questions then emerge from that, and then you decline to call any witnesses to answer any of those questions. And that, Deputy Chief Justice, Justices, is precisely why courts have to be very, very, very cautious in entering the arena. Because when you are entering the arena and you are calling your own witnesses, you have the very real danger that you are now stepping into the shoes of the prosecutor. You are now stepping into the shoes of the investigator. You now have to call a whole series of witnesses in order to answer the questions that you yourself have opened up. And what you are essentially doing now is you're driving this prosecution. And that, I would submit, Deputy Chief Justice, is manifestly not what is intended by Section 186 and 167. But here's the problem, is that witnesses who the court itself deemed were essential were not called. Issues pertaining to the activities of, or rather, who has taken possession of the firearm, who has booked in the firearm, those witnesses were not called. There was no evidence led about this other scene that is on the 11th of May. So there are now enormous holes in the manner in which you have used this 186 and 167. To the point that, Deputy Chief Justices, we still don't definitively know whether we are dealing with the 7.65 millimeter from one scene or the 9 millimeter from another scene, or whether in fact we're dealing with it's the same weapon. And that is the foundational basis on which you are starting with doctrine of recent possession. So before you have even traversed whether doctrine of recent possession can be applied to this particular situation, can be applied to the murder weapon as opposed to an item that is stolen at the property, or rather in the offense, whether it can be applied in these instances, we still, I would submit, don't decisively know which weapon we're dealing with. And if we are not sure which weapon we're dealing with, how do we even begin the process of establishing the doctrine of recent possession, where it is by its very nature a possessory claim? That is an element, a foundational element of the offense itself. If we cannot establish that it is in fact the correct weapon, how do we then draw any inferences surrounding that particular weapon? I see I've got 40 seconds of protected time. The aspects I will canvass in the, which of course are fully canvassed in the heads of argument, relating to the auto for convict, that is the 2 convictions on the weapons, as well as his submissions in respect of the sentencing, which are limited only to questions of the proportionality of the sentencing. Those are set out in the heads of argument. I see that my 30 minutes is elapsed, Judge.
Thank you, Mr. Tisani. I just want to clarify, just for myself, you make quite substantive submissions regarding the identification of firearms.
Yes.
I'm wondering, what's your objective in making those submissions? Are you inviting us to resolve that factual issue? Because it's clearly factual, it's the evidence that was given, isn't it?
Now, Deputy Chief Justice, in the sense of, am I inviting you to resolve that factual issue? No, because indeed, you've correctly pointed out, it is a factual question. What I am inviting this court, however, to do is investigate the manner and the procedure in which that was used to arrive at that particular factual question. And that's not, I would submit, a factual issue. It's not about having this court delve into, was it indeed a 7.65? Was it indeed a 9mm? It's to investigate the manner in which that conclusion was arrived at. And that conclusion was arrived at by the application of a particular procedure under the Criminal Procedure Act. That's the 186 and 167. And we would submit, Deputy Chief Justice, that that is advanced in a manner that is incompatible with the principles governing how those procedures and the discretionary is supposed to be exercised insofar as that is concerned. And secondly, insofar as what then happens when facts that the trial court itself have identified emerge and are not being investigated.
So we should accept the factual conclusion. We should not investigate it. But you want us to investigate how the court reached that factual conclusion. Is that what you say?
No.
Because
Yep.
you say the manner.
Yes.
And that's because the court invoked certain provisions of the Criminal Procedure Act in
Yes.
calling witnesses. So that's what you want us to look at.
Yes, Deputy Chief Justice. Now, the reason why is...
Well, I think you don't have to repeat yourself. You've told us why. Do I understand you to be suggesting that the exercise of that route by the trial court in recalling those witnesses was to close gaps in the prosecution case?
Deputy Chief Justice, that is indeed precisely the submission.
That's your, so, you know, it's a serious, I won't call it an allegation because you're making submissions. It's a serious thing to impute a particular state of mind on a judge. And that's what you're doing. You're inviting us to accept that the judge accepted that the prosecution case was weak and therefore she had to supplement it and she recalled witnesses. Am I correct to understand you to be saying that?
Deputy Chief Justice, you are incorrect in the manner in which you are putting it. I'm not in any way at all suggesting anything improper about Madam Justice Satchwell. I'm not at all in any way suggesting anything improper about her motivations in the manner in the matter itself. What I am inviting this court to look at, though, is you have a state's case that has irreconcilable contradictions in it that are at its very heart that would be dispositive of that case. You then have a judicial intervention. The judicial intervention itself doesn't follow the recognized principles of 186 and doesn't follow the recognized principles of 167. The consequence of that...
Are you saying the law prevented the judge from exercising her discretion to recall witnesses?
In the manner in which the trial judge did so in this particular instance, yes, Deputy Chief Justice. Because even within the manner in which you are exercising your discretion, there are still principles one has to adhere to. One has to identify who those witnesses are. Having identified who those witnesses are, one has to, in fact, call those witnesses. I mean, that's the case law with Mtsweni. Having identified issues that emerge from that, you are obliged, in fact, to do so. And those are not discretionary questions in the sense of you aren't entitled to exercise your discretion. But having elected to exercise your discretion, you then have to exercise your discretion in a manner that accords with the principles that underpin those sections. Now,
So this was an improper exercise of her discretion. That's what you say.
well, Deputy Chief Justice, one has to, the word improper is, one has to be very careful about its use, particularly when one is...
Well, let's find another word, unacceptable or unjustified. Is that what you're submitting? I don't want you to repeat yourself.
Yes, the manner in which, yes, Judge, Deputy Chief Justice, is that the manner in which this intervention took place
Yes.
is not in accordance with the principles of how an intervention of this nature is to take place. And the consequence of it is that it has arrived at certain conclusions, having not exercised. And I would submit in that regard that now is where we are now taking it out of a purely factual exercise. We're not asking this court to interrogate and decide here whether it's a 765 or it's a 9mm. But what we're asking this court to determine, rather, or to deal with is the manner in which that foundational fact was arrived at is preceded by the application of a procedure in a manner significantly contrary to the manner in which a discretion is supposed to be exercised.
Okay. Let's just move on to condonation.
Yes.
You want us to attach serious weight to the fact that we're dealing with an incarcerated person. Am I correct? Because you make this submission in your heads. You've made this submission today.
Yes, Judge.
That we're dealing with an incarcerated person who didn't have means.
And equally pertinently, Deputy Chief Justice, not only doesn't have means, but he doesn't have active legal representation, and he would have to be litigating or rather canvassing issues that are complex in nature.
Yeah. Shouldn't we also take judicial notice, if I may use that phrase, that this court in particular has ensured that the rights of incarcerated people are respected in terms of how they are treated, how they have access to whoever they want to consult with. I'm not sure if it's gone to them possessing or using laptops, but this court has been fairly active in ensuring that incarcerated people are afforded the rights they are entitled to. Should we look at that? Because what I want to ask you is, we're dealing with a person who is effectively 6 years late in coming here. 6 years.
Yes.
And we should overlook that length of time simply because we're dealing with an incarcerated person with no means, or if any means, very limited means. That's what you say.
No, Deputy Chief Justice, I would say that that is not a reason by itself. Certainly, if, again, that was the only reason he was going to say so, then one would have very grave concerns around that. What we are submitting, though, Deputy Chief Justice, is that there are a basket of considerations in respect of this particular applicant. That is one of the considerations. There are other considerations as well. There are
The other consideration is prospect of success. I think that's your argument.
indeed so.
So I've tried to look if we've had any occasion for a person who's delayed that long be granted condonation. I failed to come to such authority. Do you have any?
No, Deputy Chief Justice, I haven't been able to find.
Grootboom, how long was Grootboom? Was it, that one, was it 14 months or what?
That was, if I stand corrected, I have it here,
Less than 2 years,
yes,
Grootboom and Mantashe.
yes,
Am I correct?
yes.
Now,
The direct answer to your question, Deputy Chief Justice, is yes. I have myself was unable to find case law in which somebody, for this length of time, has been successful in the question of condonation. My answer or my submission in that regard is that again would be one of the basket of factors that may count against it, because his particular circumstances may not necessarily coterminously be as with others. Because in Grootboom you're dealing with, in many of these instances you're dealing with either at some point you have external legal teams coming in, you have persons who are assisting them. This is unique in one sense, I would submit.
yeah.
That,
Well, let me tell you why I'm asking you these questions. The applicant was represented legally during the trial, am I correct?
indeed so.
And even in initiating the appeal process up to the SCA,
Yes,
he was legally represented.
indeed so.
Well, it's not clear for me, maybe you can assist to whether it was legal aid or personal means, but he was legally represented. And whatever choices he made during the trial, in electing to keep silent and whatever, he had the benefit of legal representation.
Yes, indeed so.
And the quality of that legal representation is not being attacked, is it? It's not an issue.
Well,
It's not been raised anyway.
The quality of the legal representation is certainly not spectacular, but it would not be of such
But
a
it's
nature.
not an issue to
Indeed so.
Okay.
Yes.
Now, the explanation he gives us, the appeal failed in the SCA. He says, well, I'm incarcerated. My mom was helping me, and my younger brother who hasn't got enough means. These are all very generalized statements, right? The clock is ticking. 6 years we sit and we have those generalized statements. Why should we regard these statements as an adequate explanation of the delay? Looking at the time.
Deputy Chief Justice, the time is an enormous challenge. I would be the first to admit that. But again, I would submit that if we look at the adequacy of the explanation, it's not merely a timeline exercise. It is what is then the nature of this particular appeal? Because yes, you are legally represented up to a point, but you get now to this court, where you are now going to have to raise issues that speak to constitutional issues, that speak to the application of those issues, and you are not legally represented from the time that is happening. So you have to navigate those issues. You have to identify where you're going to take those issues. You have to identify the procedure that you're going to use to identify those issues. And you are doing that whilst you are incarcerated. Now, the persons who are assisting you are unable to do so. The main driving force behind it is, in fact, someone who ultimately succumbs. Your only other male relative is unable to assist you in that process. The timeline is substantial. Indeed it is. It is a problem. But it is also a timeline that has to factor in not only where he is, but the type of appeal he has to be advancing and the nature of the arguments that he's going to have to advance in that. Because I would submit, Deputy Chief Justice, it's one thing to delay in circumstances where you know where to go, you know what issues you are going to canvass, you know how to canvass those issues, and you just elect, for whatever reason, to take no steps. It's quite something else when somebody says, I really did not genuinely know where to go. I didn't really know how to articulate some of these positions and where I'm in fact even going to do so, particularly in circumstances where I've already lost on these issues twice. And in that sense, it's only as I'm beginning to interact with the other prisoners, it's as I'm time to interact with other incarcerated prisoners, that the outlines of a possible approach then begin to emerge, and I then take...
I think also dealing with the generalized nature of his statements, he says he sought assistance from Legal Aid South Africa, but he doesn't tell us whether it was refused, and if so, what the reasons were, and he doesn't tell us when he applied for legal aid assistance.
Well, Deputy Chief Justice, from the condonation application, we did canvass that issue with him, and his indication and his explanation was that he couldn't remember the date on which that was refused. But he did deal with the question of that the Legal Aid Board declined to assist him with the appellate phase of his proceedings, and were only willing to assist him with the trial phase of his proceedings. So the legal team that assisted him beyond the appellate phase were a legal team that was engaged on his behalf by his mother.
Okay, no, thanks, Mr. Tisani.
Mr. Tisani?
Yes, Justice.
You may have touched a bit on the question of jurisdiction.
Yes.
I just want you to just provide a more detail on that issue. Is our jurisdiction engaged for purposes of entertaining this matter? If so, what is the basis?
Yes, Justice. Justice Mdladla.
Because you mentioned that the court misapplied some of the principles, and if you agree with me, a misapplication would not be a basis for us for this court's jurisdiction to be engaged. There may be other factors that would be relevant for jurisdiction. I just want you to indicate to us clearly so that one can have that in mind.
Yes, Justice Mdladla. That issue is pertinently discussed in the heads of arguments, beginning at page 12. The starting point I would want to take justice to is obviously the matter of BUSA, because BUSA, particularly in criminal matters, established really the principles that, one, obviously purely factual issues would not be accepted as a basis to engage the constitutional jurisdiction. But it was pertinently made the position that where you are now developing the common law in a particular manner, or you are failing to develop the common law in a particular manner, that would potentially attract the jurisdiction of this court. And also where you are applying a legal rule in a manner that is inconsistent with the principle of the Constitution. Now, on the constitutional questions, we would submit in this regard is that when you are now entering, rather, you are applying a particular rule, and in particular you are applying a particular provision of the Criminal Procedure Act in a manner that is contrary to the established principles of that would raise questions about the fairness of your trial proceedings, where you are then combining that with a development of the law that is beyond the parameters of what the law traditionally is, and you are in fact taking that parameters of the law into its application to not a possessory claim arising out of theft in the actual offense itself, but in fact to a completely separate item. I would submit that that is a very distinct development of the law, and I would submit it's a development of the law that again infringes on his constitutional rights to a fair trial. Thirdly, Madam Justice, even if we were to go beyond the questions of the constitutional jurisdiction, there are also the very important aspect of the arguable questions of law of general importance. And Madam Justice will find that discussed from pages 15 to 20 of the head. But insofar as the arguable points of law are concerned, the manner in which the doctrine of recent possession has been developed, the procedural manner in which the Section 186 and 1767 has been used in this particular instance, I would submit that the combination of those two issues raise arguable questions of law of general importance, more particularly because they are not findings that are litigant specific. They go to deeper questions of when you are engaged with a 186 and a 167 procedure. Can you exercise your discretion in a manner in which you don't consider evidence that you have yourself identified? You don't investigate questions that emerge from the evidence that you are yourself calling. And yet, we must leave that question to be one that is purely factual in nature and not touching on the manner in which you've exercised your discretion. I would submit that that particular instance, you are dealing with not merely a misapplication of the law, you are dealing with an exercise of a discretion that has, the consequence of it is you are actually moving the law in a completely different direction to the established principles around recent possession. And I would submit that that would engage the jurisdiction of this court as to whether that is now a legitimate development of the doctrine of recent possession. It would also, I would submit, engage the jurisdiction of this court as to whether that is a legitimate development of the exercise of establishing under 186 and 167.
So if I hear you, well, you're saying insofar as the doctrine of recent possession, which is normally applied in respect of theft, in this particular case, the court went further, and what the court did was an extension of whether you call it a principle or a doctrine. That would be a constitutional issue on an arguable point of law, which will then clothe us with jurisdiction to determine whether or not the court was correct in doing so.
Indeed, sir, Madam Justice.
Now, let's just then deal with this doctrine of recent possession, what the court did.
Yes.
Can you just tell us why you say the court was wrong?
Well, let me just get to that. Well, Madam Justice, if we look at the manner in which leaving aside the procedural questions of how the court has arrived at the item of possession to begin with, we would submit that the challenge of recent possession. Sorry, I'm just getting to my one moment. Is that, firstly, you've taken a murder weapon that is found at a particular scene. You have placed that murder weapon in the hands of the applicant at a completely different scene. Now, that by itself is the starting point, which is that you're not talking about an item that is stolen in a particular scene. You are not talking about inferences drawn from that item. You are saying, well, let's forget about items that are not there. You have taken those items, or you have taken a weapon. That weapon is then the thing that is placing you at the scene of a completely different instance. Now, that I would submit, Madam Justice, is a striking development, because you've now taken the very nature of the doctrine out of a possessory claim, which is that you are found in possession of something, therefore, if you don't give an explanation, you must be the thief. We're not even talking about the items you have stolen. We're talking about a completely different item, entirely unrelated to that. We're talking about now a weapon which is not alleged to have been stolen at either of these scenes, but we're using it to then draw a direct linkage between yourself and these particular scenes. And having located you at that particular scene, we are then drawing inferences, not about the theft. We are drawing inferences about your participation in an armed robbery. We are drawing inferences over and above your participation in an armed robbery on the basis of common purpose. We are applying common purpose to that, solely on the basis that you happen to be you are found to be in possession of this weapon. And having found you to be in common purpose, we are then building on top of that you must have, by virtue of dolus eventualis, participated in the murder as well. So we would submit, Justice, that is the foundation of that stems from I'm taking this murder weapon, I'm using a principle that, strictly speaking, has nothing to do with the possession of a murder weapon. I'm inserting and using these two principles together to establish a presence at a scene, and I'm now drawing inferences about common purpose, and I'm drawing further inferences about intent in the form of dolus eventualis. And the starting point of that is the use of a legal principle in theft in respect of an item that does not form part of the theft at all.
Thank you, Mr. Tisani. Thank you, TCJ.
Thank you.
Thank you. Mr. Tisani,
Yes, Justice.
we have lots of cases that come to this court years after sentence. And some of those, or most of those applicants are incarcerated. I just want to find out from you whether you are saying that if there's an application for leave to appeal and a lot of time has expired, let's say 10 years or so, or 6 years, and we find that there are certain factual problems that we have identified there, should we then take all those cases and find that we've got jurisdiction in those circumstances? If you say that we should not take all of them, I'm interested as to what criterion should we then apply? That's my first question.
Yes, Madam Justice Chitler. Certainly, in answer to your first question, this court cannot take on all and sundry. There will be many instances where there are factual disputes that have to play themselves out. And indeed, if they've played themselves out fully in the High Court and they've played themselves out in appeal courts, that's usually dispositive of it. Where I would submit in this instance, Madam Justice, is that this is not a run-of-the-mill, this is a purely factual question. As the Deputy Chief Justice has correctly engaged me with, if we're going to be talking about factual issues of the lower court, we cannot be having that conversation here. This is not about attempting to resolve those factual disputes. It is about interrogating the legal principles that were applied in the application for number one of a particular procedure, which is under the 186 and the 167.
Okay, sorry to interrupt you. Are you saying that whenever in those cases, let's say an application is brought after 10 years today, if there was a problem or there was an error that the court made, so in all those cases we should interfere? Are you submitting that?
No, Madam Justice, at all. The delay is a significant factor that must distinctly count against a litigant in those circumstances. And the applicant is certainly not going to be in a position to run away from that issue. But that is a factor that has to be weighed against the type and the nature of issue that he's bringing before this court. If you have a lengthy delay and you are bringing a run-of-the-mill issue to this court, there's likely nothing to talk about.
That's where I get lost, because I don't understand what you mean run-of-the-mill. Is, if you can just explain that, maybe I'll understand better.
Well, Madam Justice, perhaps I should, the use of the word run-of-the-mill was not correct. There's no legal issue that is run-of-the-mill. If we are not dealing with a subject matter that directly engages the constitutional jurisdiction of this court, we are not dealing with a matter that directly engages arguable points of law of general importance, in which the interests of justice are met. If we don't locate it within that jurisdictional question and those jurisdictional boundaries, then I would submit one would then not at all be able to overlook a substantial delay. And I would submit in two respects. By run-of-the-mill, I'm not suggesting that matters are simple. It is that if we are dealing with a matter that...
You have explained, I'm
Yes.
sorry to keep on interrupting you. I just want us to have sort of a debate, because I just need clarification as to what criterion we need to use if an application is brought by a person who has been incarcerated and a long time has expired after the sentence. So what, you're saying that if we find in that application that yes, the application is long or is delayed, we should look at whether if it was brought in time, we would have jurisdiction or not.
As a starting point, yes, Madam Justice. One would obviously have to firstly locate that it is a type of matter, objectively, leaving aside the lengthy delays, that would warrant the attention of this court. If you are unable to establish that, then I would submit that would then be dispository of your condemnation. Having established that, this court would then have to weigh the delay in, I would submit, analogously, the same way it would weigh any delay in any condemnation application, as to where do the scales tip. Is the delay of such a nature that it's just so egregious, notwithstanding the merits of your matter, this just cannot be countenanced and we have to close the door on this? Or is it, yes, your delay is very egregious and very significant, but the questions that you are raising are of such a compelling nature and your prospects in that regard are of such a nature that notwithstanding that egregious delay, this court can nevertheless entertain it. And I would be hesitant, Madam Justice, to suggest that there's an artificial cut-off point. Because if one were to say 5 years, one could talk about 6 years or 7 years or 10 years. It, I would submit, comes to a balance of scaling of the lengthier your delay, the stronger your prospects need to be, and the more important the questions of law that you are raising. And I would submit that that is the criteria I would submit is the appropriate one to weigh insofar as assessing this particular condemnation. Is that where there is a lengthy delay, there would then need to be a very, very important question of law, and one would have to have very strong prospects on answering those questions of law in your favor in order to overlook a lengthy period of delay.
On a different issue, if we were to grant leave in this matter, and determine this matter. What in your view should we do? Should we then, if we grant leave to appeal, delve onto the factual disputes? Are we in a position to do that? If not, I'm not suggesting we not. I'm saying if not, can we remit this matter to the High Court? And if we remitted it to the High Court, what are the implications of the delay for the High Court? If we were to determine it ourselves, what do we do with the disputes of fact?
Well, Madam Justice, insofar as the delving into the merits of the matter is concerned, delving into the merits of the matter would have to be dealt with insofar as what is possible within the confines of this court. The nuts and bolts of who gave evidence, what, where, whether we're dealing with firearm X or whether we're dealing with firearm Z, those are questions that would never be capable of being answered in this court. They would not questions that would be capable of being answered in any court. But I would submit, Madam Justice, if this court, as I submit, should find that there are procedural questions, particularly insofar as the correct application of the interventions into the proceedings under the Criminal Procedure Act, as well as the manner in which the doctrine has been developed, that if those are wrongly decided as legal questions, I would submit that the logical consequence of that would be that it's not a factual question. The applicant could not have been properly convicted if this particular firearm is A, indeed the one common to both scenes, and B, that the doctrine of recent possession can in fact be developed in this particular manner. So if this court, I would submit, finds that neither of those can be sustained, the consequence of that, I would submit, is that he couldn't then properly have been convicted in those trial proceedings.
Okay, let's deal with the doctrine of recent possession now.
Yes.
Are you saying that the judge developed the doctrine of recent possession simply because she referred to S versus Blom, or are there instances in the judgment where she specifically speaks to recent possession and where she says it should be developed?
There are no instances in the judgment where the Madam Justice Satchel is specifically indicating that she's developing the law. In other words, she's not sitting and saying, I'm developing the law of recent possession in this particular manner. But what she is doing is she is citing the item of possession as being a murder weapon. And more importantly, not an item that she finds anywhere in the judgment was stolen at the scene, was taken from the scene, formed part of the theft, formed part of anything. Essentially, what Madam Justice Satchel is doing is the evidence of the inspector, Mr. Poswa, is that I'm finding this weapon in a possession of the applicant. There's then second evidence of an Inspector Maloma who says this weapon that was found on date X is in fact the same weapon that was involved in the events of this particular incident. And there's then a direct application of the doctrine of recent possession to that. In other words, that you have this weapon that is there is then the linkage between the two on the basis of the doctrine of recent possession. What there isn't, milady, is any discussion or interrogation in the judgment itself as to whether it in fact is even permissible, firstly, to apply the doctrine of recent possession to a murder weapon in those circumstances, and if so, how would that then locate itself within the context of a possessory claim? So,
the question I want to clarify in my mind, this is why I'm asking you this question, is whether the High Court relied on circumstantial evidence or whether it used the doctrine itself. And I'm now looking at page 200
yes.
of the record, and I'm looking at the record in paper, basically. I'm not looking at case lines. And I'm in page 200 from line 10. After line 10, that is where the court refers to R versus Blom.
Yes.
And then after that paragraph, then that is where the court says, in the present case, it was proven that he was in possession of the murder weapon, and he was in possession within less than 2 weeks. And then it says the inference which the state seeks to draw is that he was in possession of this murder weapon on the 28th April. Is that what you relate to as the application of the doctrine of recent possession?
Well, Milady, Madam Justice, if I may answer it in two respects. Firstly, insofar as the doctrine of recent possession is concerned, it sets out certain requirements that have to be met in order for it to be applied.
Are they set in this judgment?
They are not.
Does the judge say the doctrine of recent possession requires this and that and that, and I'm satisfied that it has been satisfied, or it has not been satisfied because so and so is lacking, and therefore does she then say, I'm developing that doctrine of recent possession because what. I just want to find it in the judgment where she says that, or something like that, something similar to that. I just want to satisfy myself that the High Court did develop the common law.
Madam Justice, you will find I'm going to the judgment itself. There is discussion, I beg your ladyship's pardon. The discussion then begins in section, rather page 198. Now,
9A.
yes, you are not going to find an indication that she is indicating that I'm now developing the doctrine of recent possession. What you are finding is a discussion beginning at page 198, is that there is you are in possession of a particular weapon. I am eliminating in my mind the fact that you don't seem to have explanations for this firearm. You don't seem to advance any reason for it. I'm not going to speculate on your behalf as to why you are in possession of this particular firearm. Now, I would submit, my lady, that the doctrine of recent possession is not, we shouldn't separate it in the sense that it doesn't itself inherently involve circumstantial reasoning. It does. But the essence of it is that if you are in possession of an item which is credibly found to have been recently stolen. The nature of such an item requires you to provide an explanation for why you are in possession of it.
Yes, I'm acquainted with the doctrine of recent possession. What my question was, I'd like assistance from you to determine whether in fact or in reality, that is what the court did. Did it develop the common law of the doctrine of recent possession? And where should I find that? Yes, there's reference to possession. Yes, reference to the fact that the crime occurred on this day, and Mr. Chabangu was found in possession. I'm asking, should we then infer from those references that the High Court judge was dealing with the doctrine of recent possession? And I'd like you to then direct me to a place where I can then find that indeed she developed the common law in saying this.
But my submission in this regard would be that, again, you are not going to find the specific reference to, I am now developing the doctrine of recent possession. That you are not going to find in the main judgment. What you are going to find is discussions of the evidence, why she has accepted that the firearm at a particular scene is of a particular nature. Then a discussion about why that particular firearm found after 2 weeks from the date on which it has been now from the previous offense is then inferred to be in the possession of the applicant.
So,
and that,
so we are not going to find a direct reference to it.
Not to the doctrine of, in other words, she's not using, what you are finding, my lady, is you are finding from 198 to 199 to 200 onwards, is that a discussion of a weapon is found in your possession. Barely 2 weeks, there's evidence that you are involved in, rather, a weapon is found in your possession. 2 weeks after that weapon is found in your possession, or rather 2 weeks before, there is another incident that took place.
Can I ask a different question? Is there anywhere where the court says the doctrine of recent possession should not be restricted to theft cases only, but should be applied to the subsequent discovery of murder weapons that were allegedly used in the other crime?
Well, Milady, if...
where the court makes that general principle.
In this particular judgment, no, Milady, Milady, you are not going to find in this judgment, Madam Justice Satchwell saying, I am developing the doctrine in this particular manner. But what we are submitting, Milady, is that when you look at what she is in reality doing, that is, here is a weapon at one scene. It is 2 weeks later from when the murder took place. You have provided no explanation from this, therefore you must have been in possession of that weapon. The only doctrine you could be providing that in that is recent possession, Milady. Because the circumstantial evidence that you are relying on is that having been found in possession of an item 2 weeks hence from the original occurrence, I'm inferring that you must have been in possession of it at the time. That, I would submit, Madam Justice, could not be anything other than an application of the doctrine of recent possession, because there is no circumstantial evidence that would point to your possession of that item on the 28th of April. in circumstances where there is in fact no eyewitness, or in fact any witness who has placed the applicant at the scene, the first scene, at all. The only thing placing him at that scene is evidence of, you're found with something, I'm inferring, therefore, that 2 weeks ago you must have been in possession of that particular item.
Thank you. Thank you, TCJ.
Mr. Tisani, on this side.
Yes, Justice.
For you or for the applicant to get in through the door of this court, firstly, you have to satisfy the threshold of condonation. I'm going to read you a judgment of this court, which more or less has similar circumstances like this one. It's a state versus Sithole. It's a judgment written by my sister, Mhlanhla. It was delivered on the 20th of December, 2024. It's still recent. It's not mentioned in your heads. You're not aware of it. Let me quote the paragraph that deals with condonation and tell you what it says. Paragraph 21. The judgment says the application was filed more than 6 years after the dismissal of the application for leave to appeal by the Supreme Court of Appeal. In essence, this is what the judgment says. The applicant submits that the circumstance of his incarceration prevented him from bringing the application timeously. The explanation for the delay is tenuous. However, I'm inclined to accept his explanation about the difficulties encountered due to the fact that he is serving a sentence, which can be a significant obstacle for timeous filing of an application to this court. Furthermore, the respondent does not oppose the condonation, and the granting thereof will not prejudice the respondent. Therefore, condonation is granted. What is your response to what I've just quoted?
Justice Matopa, I'm very grateful to have been made aware of this.
Can you please just speak up?
I'm very grateful to have been made aware of this particular matter, Madam Justice. I must confess, in my reading, it's not a case that I was aware of before now. Insofar as the facts as you are describing them may be coterminous or may be similar to the ones that are here, I would submit, Justice, that that would indeed align with the profound difficulties that the applicant in this instance is describing.
So let me put it this to you.
Yeah.
If the explanation of the applicant are tenuous, and if the difficulties that the applicant encountered are similar to the difficulties and the explanation is tenuous, like the Sithole one, the only point that you would wish us to address is whether the opposition, there is opposition to condonation or not. In other words, this court has spoken, has granted the indulgence where the period is more or less the same as this one. Unless we are to say the judgment there is clearly wrong, we have to interfere with it.
Justice Matopo, certainly in answer to you, I would submit that if in similar cases the court has granted condonation, then that would indeed be something that would weigh favorably in respect of the applicant is concerned. And indeed, in this instance, there is also no, as I'm aware of, formal opposition to the question of condonation. But I would submit, though, as much as I would want to rely on a judgment that is in my favor, apparently. I would not, though, want to discount the fact that condemnation is fact-specific, and it is situation-specific, and one has to be hesitant to draw direct analogies between two instances of condemnation. But I would submit that,
You would embrace it.
indeed so.
There is also a judgment, Van Wyk versus Unitas. It's not mentioned in your heads. That judgment says, if it is in the interest of justice, condonation ought to be granted. Now, given the facts of this case, would one say it's Van Wyk versus Unitas?
Yeah.
It's an old case. I think it was written by Cameron J, if I still remember. It says, if the interests of justice favor the grant of condonation, and it has to be granted. But now the inquiry would be, do the interests of justice in this case favor the granting of condonation? If so, what are those interests of justice? Just briefly, I know you've made your submissions. I just want to know them.
Insofar as the interests of justice are concerned, Justice Matopo, I would submit that in this particular instance, if one has regards to the manner in which the doctrine has been not only applied but developed, if one has regards to the manner in which the court has intervened in arriving at those particular conclusions under Section 186 and 167, if one has regards to the importance of a finding of a court in which a definite finding of guilt has been made against the applicant in circumstances where the only logical connection.
Okay, all right. I have here, you say the interest of justice would be the doctrine of recent possession and the invocation or the calling of witnesses in terms of Section 167 and 186 by the court. It's an aspect that you have debated with the DCJ. Is there any other? And overall, you say the finding of guilt, which probably, as I listen to your evidence, your submission, you say it does not account for all the evidence.
Indeed so, Justice Matobo. It would also be in the sense that the interests of justice, over and above the importance of the matter itself, do obviously weigh distinctly on the prospects of success. And we would submit that there are distinct prospects that another court would, or rather this court, would draw very different conclusions on the manner in which the doctrine is developed and the manner in which these have done by the original trial court, such that on the substantive merits of the application, of the appeal itself, that would be then successful.
I've given you two cases. I'll give you the third one. They probably are all in your favor, depending on how you look at it. There is another case of Nochawa versus the Makana municipality. It's a 2019 judgment, where this court held that where the facts of the matter demonstrate a clear breach of the Constitution, then a court may similarly decide to overlook an inordinate delay in order to uphold the Constitution. Now, what I would want to establish from you, this is the third case that seems to support your argument on condonation. But I don't want to accept them as is, because each case has to be decided on its own facts. They may be distinguishable to this one. Now, for us to accept or to arrive at the conclusion that they are or they may be distinguishable or align with your argument, I think an opportunity as now has to be given to you. Now, is there any breach of the Constitution when you look at the facts of this case? And if so, what constitutional rights of the applicant is been breached or are being breached?
Justice Matobo, I would submit that the right to a fair trial is foundational in that it has to be, number one is conclusions in that trial have to be arrived at in accordance with established principles. Number two, I would submit that the factual and the legal procedure used in those proceedings should follow recognized applications of discretion and recognized applications or recognized principles of the law. In this instance and procedure, you have significant departure from what is taking place, what should be taking place under the relevant sections of the Criminal Procedure Act in terms of the judicial intervention into this particular matter. You have a significant development of a doctrine that is applied. You have a finding that is disconnected from any external evidence about the involvement of this particular applicant, and based on the novel development of that particular doctrine, you then have...
Sorry, please allow me to interrupt you for the sake of progress. You said the rights to a fair trial of an accused person, of the applicant in this case,
Yes,
has been infringed. So that is the breach of the Constitution,
indeed so.
right? And if you put facts to that, you would say the application of, was there any application of the doctrine of recent possession?
I would submit... I beg your pardon.
If the answer is yes, the debate that you had with my sister Chikwi,
Yes.
yeah, if the answer is yes, obviously I would invite you to draw our attention to the judgment itself, where the learned judge dealt with it. My recollection, I read it quite a long time ago. I don't recall the learned judge having pertinently dealing with that doctrine. Is it somewhere in the judgment?
Well, Justice Matoba, not to re-engage with the...
No, but if it's not in the judgment, you can't say there was a development of the common law.
Justice, with respect, I would submit that if you are dealing with a judicial, a judgment that says you are taking what is happening at one scene, you are accepting that because the person is in possession of that item at that one scene, they must have been in possession of that item at another scene. You cannot be doing anything other than applying the doctrine of recent possession.
Yeah, but why can't it be that the judge was dealing with or applied the State versus Blom principle to say the inference that is sought to be drawn must be consistent with all the facts. And if it's not consistent, that inference must not be drawn. That's what Blom tells us.
Indeed
So that's, my understanding is, that is what the judge did.
Justice Matoba,
Is that not so?
in this instance,
We are in this instance.
she cannot have been applying the principles of Blom in the sense of it's consistent with all the proven facts, because insofar as the applicant is concerned, there are no proven facts.
But if the judge said, I am drawing the inference that an offense occurred 11 days or 13 days ago, and the firearm was found in your possession, because the firearm was found in your possession, the inescapable inference that I need to draw from those facts is that you are one of the perpetrators. This is the application of Blom. There's nothing like recent possession.
My lord, I would submit
You accept that or you don't? If you don't, we'll have to look at the record, and the record will tell us whether I'm correct or not.
my lord, I would not accept that proposition in the sense of, once we are dealing with a judgment that is talking about, I am accepting inferences in the application of SV Blom, you are then dealing with it in a circumstance of there are facts that are particular to this witness. I am drawing all of those facts, and I'm drawing inferences in relation to those particular inferences.
So you would
In this instance,
you then say the judge applied both the doctrine of recent possession and Blom.
insofar as the application of the doctrine of recent possession to the applicant is concerned, in this instance, there are no external facts that against, in fact, even the judgment itself is that the only evidence against the applicant is possession of this particular firearm. And that possession is not a possession that is inferred from any other circumstantial fact. It is a possession that is inferred from he's in possession of it on day A, he must have been in possession of it on day B.
Okay. Let me conclude this. This is what I wrote while you were arguing. If a court, just listen very carefully, if a court is silent about a legal principle that it ought to have applied, right, can it be said that it is a misapplication of the legal principles, what the court did, or an error of law? Do you follow the distinction? I know it troubles a lot of counsel who appears in this court.
Yes,
Here we're talking about the silence of the court. If the court is silent about a legal principles that it ought to have applied, can we say that it has misapplied what it did not say or state, or that exercise of the court in arriving at a particular conclusion? Does that constitute an error of law?
Munir, I would submit in this instance, one is dealing with the second of those aspects, which is that you are
Perhaps let me not ambush you. A misapplication of the legal principles does not engage our jurisdiction. Have that at the back of your mind.
indeed, so, Munir. Now, my lord, my submission in this regard is that we are not in this instance dealing with a misapplication of the legal procedure, because you have a general discussion from the court about the circumstances under which she has found that it's the same weapon. But I would submit in this regard, if one has regards to the totality of the judgment, the starting point of the judgment is there is no external evidence about the possession of this weapon, and more importantly, there's no external evidence about the involvement of the applicant in this matter at all. The only thing there is.
I don't think you seem to recall the exchange you have with the DCJ, that this court does not involve itself or entangle itself in factual inquiries. Now, what you've been doing throughout has been a regurgitating of the facts. And if your case is founded on the facts, despite what I've sought to bring forward and put on your lap, if you don't embrace it, then you have a problem because we don't deal with the facts. And that's what you're inviting us to do.
Justice Matobo, I would submit in this regard is that we're not inviting this court to get into the weeds, and we're not inviting this court to get into the nuts and bolts of it. What we are inviting this court to do is to examine, number one is the manner in which the doctrine is applied, and I would submit that the only conclusion that could be drawn from the record is that indeed she is applying the doctrine of recent possession in arriving at a conclusion.
Let me just see if I can come to your assistance. If the invitation is we should deal with the facts, that invitation would not be lightly accepted, one. But if the invitation is that the facts and the law, the legal principles, are bound together, there's authority of this court that we can deal with it. 3, if the submission is anchored upon misapplication of the legal principles, that does not engage our jurisdiction. However, if the submission is that what happened in court constitutes an error of law, that would engage our jurisdiction. So, in other words, what I'm putting to you is, firstly, you have to surmount the hurdle of condonation. Once you've surmounted the hurdle of condonation, then you are confronted with the 4 propositions that I've just put to you for us to find jurisdiction. And after finding jurisdiction, then we will decide whether there is merit in the matter, in the application or not. Do you follow where I come from?
Indeed, Sumano. Justice, if I may refer you, I believe I've in my head referred this court to the judgment of Basson. The judgment of Basson, which your Lordship will find on page 19 and 20 of the heads of argument. And therein, it was dealing with the interpretation of the Mahmoud judgment in terms of how was then one distinguish what are purely factual questions from purely legal questions. And therein, of course, there were the 3 determining factors. If something is just purely an inference of fact, then indeed it is no questions of law arise. If something is a pure question of law, then it does. But there's a third category, Justice, and that was the one that was pertinently discussed, your Lordship will find on page 20 of the heads, is that there are also instances where there are mixed questions, which is that there are some aspects that are of fact and there are other questions that are of law. If the only thing that is being canvassed alone is one of a purely factual conclusion, that would certainly not place it within the jurisdiction of this court. But if the question is whether the facts that are being advanced are sufficient to justify the legal conclusion, that then is a question of law. And I would submit that that's the jurisprudence of this particular court.
But why don't you tell us about the unsound conviction, to say whether can we go to sleep and knowing that there has been an unsound conviction, somebody is in custody. Let me put an example. If you were to give me your bag, right, and I would hold your bag, perhaps you go somewhere for a few minutes, and lo and behold, there's a firearm in your bag, and the police come and search me, and they found a firearm, and the firearm is ballistically linked to an incident that happened maybe 3 or 4 days ago, and I'm zapped for that. And imagine now if I have to go to jail, it's that conviction sound. And if that conviction is sound, does the Constitution allow that an accused person must go to jail on the basis of an unsound conviction?
Justice Matobo, my submission in that regard is undoubtedly not. And in fact, that is at its heart where the present application finds itself, is that one is the misapplication of the legal principles as in fact resulted in a conviction based on unsound principles of law. And we would submit that in that instance, those are not factual questions, those are legal questions. And they are legal questions which should be answered in favor of the applicant.
Lest I forget, there is also a judgment of this court in State versus Tuta. I'm not sure if you are aware of it,
Yes, sir.
where this court found that there was an error of law, it interfered, and the conviction and sentence were set aside.
Yes, sir.
You may have to look it up in your reply. Okay. I may have more, but I'll leave the more to my colleagues.
Thank you, Mr. Tisani, and mindful that you are appearing pro bono here. It does seem that notwithstanding the generosity of my colleagues and a diligent search, we haven't really come up with anything that suggests that the High Court had applied the doctrine of recent possession. If anything, it articulated the test for inferential reasoning and then applied that test. If it applied that test incorrectly, as my brother Justice Matopo indicated, it would not engage our jurisdiction, but it does seem it applied the test correctly because it concluded that a reasonable inference that could be drawn was in fact that Mr. Shabangu, in whose possession a firearm was found, firearm was handed in, that same firearm was checked out, that same firearm was subject to testing, and that same firearm was found to be a murder weapon, that it was a reasonable inference that, in fact, he was on the scene of the murder. The High Court also said that it was not incumbent on the court to close the possibility of any other inference. And that really is alluding to his absence to give evidence. It wasn't the duty of the court to do so. And so that being the case, I think it might be prudent to accept that. On the face of it and on the judgment itself and on every reasonable interpretation of the judgment, the court engaged in inferential reasoning and did not rely on the doctrine of recent possession. And if anything, on the facts, which we don't need to get into, it was satisfied that those facts were sufficient to sustain the reasonable inference that it did in fact draw. Yeah. That's just my take of it. You don't have to comment on it because you have engaged with my two colleagues substantively, and I don't think if you provide an answer, it'll probably be a repetition of what you've said.
Justice Colopin, again, quite correctly, I wouldn't obviously want to repeat what I've advanced to the other justices. The one aspect, though, I would wish to deal with, though, is that the notion that one is arriving at a particular factual conclusion about the firearm itself, that presupposes that the application of 186 and 167 was done in a manner such that that legal conclusion of being in possession of the firearm could have been done in the first place. And I would submit, Justice Colopin, that if one has regard to the manner in which the section 186 and the 167 in this instance was done, that is not in fact a conclusion that can be sustained.
I've had a look at the record carefully, and the judge was, in fact, concerned about the possible discrepancies. At the end of the day, the judge deals with it quite compellingly with regard to how she sees the chain and concludes that whether there was a misunderstanding of whether it was a 7.65 or a 9 millimeter doesn't really feature at the end of the day, because the only firearm that was found by Inspector Posa on that day was one found on Mr. Shabangu, and that was the firearm handed in. And that was the firearm that Inspector Ota checked out and that was tested. But we don't need to get there, because even if the judge was wrong on that, that was purely factual. So perhaps we leave it at that. Thank you. Thank you, DCJ.
Thank you, Mr. Tasani, over here. I'm just interested whether you are suggesting that this court should revisit Busak and the test that it has applied there in terms of, this, as far as the circumstances in which this court will find that a constitutional matter is raised that warrants its consideration. So particularly in that case, as my colleagues have referred to, where the evidence is sufficient to justify a finding beyond reasonable doubt that an accused is guilty of an offence cannot in itself be found to be a constitutional matter. That's the reasoning in Busak, and that the only proviso seems to be that unless another constitutional matter is raised, or the application of a rule may be that constitutional matter which is inconsistent in some way with the right in the Constitution, right or principle of the Constitution. So my concern arises, I share what my colleague Justice Colopin has said, is that it seems to me that the argument relating to the doctrine of recent possession is a red herring, as is the issue around the gun. And if we accept that the firearm is found in the accused's possession and that an inferential reasoning was then found to convict him, are you then suggesting this court would have jurisdiction even in circumstances in which Busak has held, or this court in Busak has held, that such a finding as to whether that's been proved beyond reasonable doubt is in itself not sufficient to cause a constitutional matter to be considered by us?
Madam Justice Savage, the straightforward answer is it is the full body of law consistently applied that factual issues, if that is essentially what one is dealing with, those are issues for the trial court, those are issues for the perhaps an appellate court if it's dealing with it. This court is not seized with purely factual questions. So if the finding of this court is that these are all red herrings and there's no legal issues involved, and one is then dealing with facts, then indeed, from a factual perspective, this is not the court to deal with questions of fact. But of course, the applicant's submissions in that regard are that these are not factual questions, they are legal questions that do involve the jurisdiction of this court.
Yes, I saw your argument and I saw your reference to Basson in that regard. But I suppose my concern is, what about the right to a fair trial? I mean, it's a starting point, not a consideration of the right to a fair trial. What, for instance, in a circumstance where there had been an absolute failure on the part of the trial court to properly assess the factual evidence, and that the trial court led the trial court to a conclusion that there were facts beyond reasonable doubt which proved the accused's guilt in respect to an offence. If it were to determine that that was simply a factual issue, would then, on its current jurisprudence, not engage in an inquiry into the matter, although it is the constitutional court and a fundamental right is concerned, which is that in section 35 relating to a fair trial. If you had any comments on that.
Madam Justice, I would submit in that regard, if one is dealing with an instance where you have a court that is flat out not applying its mind at all, it's arriving at conclusions that no other court could deal with. It's arriving at considerations that no rational court could arrive at. That then would raise a constitutional question, but in the context of you now have, for want of a better term, a want of a judicial failure to apply the mind in a manner in which any judge could have done so. Now, in that instance, I would submit that perhaps there may be occasion to develop the jurisprudence in that direction, that in that instance, there may well be need for the courts purely on the basis of a fair trial, that in circumstances where somebody has completely failed to apply their mind and for whatever reason an appeal court has completely failed to pick that up as well.
But is that not involving the court in a consideration of the facts? Because to come to that conclusion would require the court to have regard to the facts. That's really my concern.
Well, it may, in that instance, and it would, of course. But there would be, of course, other considerations over and above the pure consideration of the objective consideration of the facts, which is the manner in which the court is conducting itself, the manner in which it's applying its discretion, which go to the substantive content of the trial itself. It's not on a question of pure fact, as in trial court says it's A, can the Constitutional Court go and say it's in fact B? I would submit, Milady, if one has regards to the way Section 1673 is formulated, it doesn't envisage the courts delving into a purely factual question.
Over here, Mr. Tsesani.
Yes.
Am I correct, or am I understanding your argument correctly, that you are not asking this court to make any factual assessment? You are asking this court to explore the legal building blocks of the inferential reasoning that went into the conviction of Mr. Shabangu. In that regard, if I understand your argument correctly, you're saying explore that which triggered the exercise of the discretion in terms of Section 86 and 167. And you're saying that you cannot use inadmissible evidence, which was the evidence presented by accused number 1, against Mr. Shabangu in order to trigger the exercise of that discretion. So that is how the learned judge started by recalling those witnesses. Then the next step was, having identified that or having then thought that she had a discretion to exercise, she identified 5 witnesses and only called 2. She should have engaged or should have called all of them, because the object was to investigate what accused number 1 had said. So there was no evidence on which to convict Mr. Shabangu on the case of murder prior to the calling of these witnesses. So you're saying these legal triggers, firstly, did she have a discretion at all under the circumstances of this case? Was it triggered? If it was triggered, was it exercised correctly? And then the final issue is, can one then conclude beyond reasonable doubt that she, and all of those issues engage the jurisdiction of this court and does not require of this court to make factual findings.
In a nutshell, Madam Justice, indeed so. That is the very essence of our argument. That this court is not a court of fact. It is a court of the legal conclusions on which, or rather the legal building blocks on which those conclusions are drawn. And we would submit indeed that the misapplication of the principles of Section 186 and 167 allowed Madam Justice Satchell to arrive at conclusions that were not permissible, legally permissible in the circumstances. And those are legal questions, those are not factual questions.
Thank you.
Mr. Tsani, I wonder if you can perhaps draw the distinction between ordinary inferential reasoning, or let me ask the question this way. Is there a difference between ordinary inferential reasoning and the principle itself of recent possession? Because it seems to me, this strikes me as the exchange between yourself and the bench is developing, that the principle of recent possession may itself be a reasoning that's based on inferential reasoning. And the distinction could be more of a matter of form than substance. In other words, the principle relates to a person being found in possession of an item. And there having been no explanation and the time frame being integral to the reasoning, which are all factors that the High Court mentions. The period of 2 weeks is mentioned a couple of times. The absence of explanation on numerous occasions is mentioned. So I'm trying to, I do not have an answer for it, but I'm trying to work out whether there is really a distinction between a conclusion based on inferential reasoning and the principle of, or just an application of the principle to the fact. Because the other problem is that often judges don't set out the first principle, they just reason out. And sometimes it can be difficult to work out which principle, if the principles converge, the judge was actually applying. So sorry for that long question, but what I'm trying to work out is the distinction between circumstantial reasoning and the principle of recent possession itself.
Justice Tambozo, my understanding of it is that inferential reasoning as essentially for want of a general category is that it requires that there are certain objective proven facts from which you are then drawing conclusions about that are consistent with those objective proven facts. Now, that's the broad principle around it. The recent possession has elements of that, undoubtedly, in that there are certain factual requirements that have to be established in which to establish recent possession. So conceptually, yes, you are using inferential reasoning to arrive at that you are in recent possession. Where the distinction is, though, is that reliance on recent possession then has very specific issues that have to be present in order for them to be applied, and absent those principles or those factors being present, one would then not be able to arrive at it. It has to relate to, of course, a stolen item. It has to relate to something that is within the meaning of the law recently in someone's possession. And those are aspects that are particular to recent possession.
Thank you.
Mr. Shabangu.
Tisan.
Sorry, I'm so sorry. Long day, Mr. Tisan, I'm so sorry. Mr. Tisan, if we are to accept what the judge says in her judgment, that she considered the matter on the basis of the rule set out in R versus Blom. She says so at page 200, I think line 11. And then she then comes to the conclusion that she comes into. Why should we not, if we are not happy with the conclusion that she gets to, why should that not be regarded as a misapplication of that rule, which appears to have been at the forefront of her mind when she considered the matter?
We would submit, Justice Nuku, is that before we even get to the application of that rule of possession, is the firearm itself and the manner in which that firearm has been identified, such that it then triggers inferences about who, what, and under what circumstances the possession may have been. If you are arriving at that conclusion purely based on logical A minus B equals C or the like, that's then a purely nuts and bolts factual question, and that wouldn't trigger. But if, in order to even start that exercise, we then have to look at how have you even arrived at this is the firearm. And that's why the structure of the argument preceded with the discussion of the firearm didn't arrive out of nowhere in terms of it's now factually established as the firearm.
Can I just interrupt you so that I can put context into my question?
Yes.
I ask this question because in my mind, this court is no ordinary court of appeal. It has to settle the law, hence it won't delve into factual issues. Where the judge applies a particular rule and does so incorrectly, it's not a matter that should ordinarily concern this court because the state of the law has not been interfered with. Isn't that a fair proposition?
It is, Justice Nuku, in the sense that if one is dealing purely with the court has made a mistake about getting to the wrong conclusion, certainly that is the mistake of that particular court. And if that is the number of an appeal, then certainly it wouldn't engage and trigger the jurisdiction of this court. But our submissions in this regard, though, are that that's not what we're dealing with here. We're not dealing with, okay, Procedural has made a mistake, and let's try and get this particular court to fix.
Accept that you have made your submissions in that regard.
Yeah.
Now, if the court were to accept that the High Court applied the rule regarding inferential reasoning and got to a wrong conclusion, on those, and that resulted in an unsound conviction, would that be a basis for this court would that engage this court's jurisdiction?
On the current jurisprudence, as my understanding of it, no. In that if one is not dealing with fundamentally legal conclusions, one would then not trigger the jurisdiction of this court unless you are locating yourself within the confines of Bason, whereas you are saying that fact A and fact B are not sufficient to sustain a legal conclusion.
Which is the case that you are presenting to us? Is that the case? Person, is that the case
Yes.
you are making to us?
Now, in this instance, the reference to the Basson judgment is in reference to that in order to get to a legal conclusion, there are certain building blocks that have to be in place. And those building blocks have not been, either haven't been laid at all, or where they have been laid incorrectly. And we would submit that the essence of this appeal is that when you are now dealing with the legal conclusion that arises out of that, not the factual conclusion, one is then dealing with whether the, not with findings of fact, but with findings of law in that instance. And we would submit, in that instance, then you would be triggering the jurisdiction of this court.
The other issue I would want to just debate with you is you have made passionate submissions regarding this doctrine of recent possession. But the judgment is silent on that. And now, on the face of that, it would not appear, it appears that there would be nothing for this court to correct because the judge did not go there. I think that's the difficulty we have with this submission about doctrine of recent possession. Because had she, I think, Justice Chikri proposed to you, had she mentioned that she was considering the matter in relation to that doctrine and that there are these shortcomings and then she was developing it, then that would be something for this court to consider. Now this court would have to start from scratch and say, forget about what she said the rule that she was applying. I think she was considering this rule and she got it wrong. Wouldn't that be a bridge too far?
I would submit no, Justice Nuku, because the danger is in form over substance. The fact that a judgment may be not using the precise terminology and articulating, I am developing the doctrine of recent possession in this particular manner, doesn't mean that when one looks at the totality of the judgment and one looks at what is in fact taking place, that is not in actual fact what is happening. That if one looks at an analysis of a judgment purely based on its outward form, one is then going to lose the substance of what is taking place. The substance of what is taking place is there's no connection between the applicant and the second sin. And that is a fact that is even accepted in the judgment itself, bar for the manner in which he has applied the doctrine bar for the fact that he is now found to be in possession. And I would submit that if you interrogate how that conclusion has been drawn, that is not the conclusions that is compatible with the application of inferential reasoning. That is a conclusion that is compatible only, I would submit, with the application of the doctrine of recent possession. And even if she's not saying so in so many words, the substance of what is taking place in this judgment is the application of the doctrine of recent possession. And I would submit that this court is entitled to view the substance of the judgment over the form in which that judgment is taking place.
And then lastly, in relation to the invocation by that court of the powers in section 167 and 186 of the Criminal Procedure Act, I heard you say that the complaint relates to the manner in which those provisions were invoked. Is my understanding correct? Did I hear you correct?
Well, firstly, Justice Nuku, in order to engage in an exercise under 186 and 167, one has to firstly be taking the view and taking the conclusion that it is necessary to achieve a just decision, insofar as it pertains to the matter in front of the court. Now, the reasoning of this particular court...
No, as a starting point, you can just say, no, you didn't hear me right. I didn't say that I didn't complain about the manner. And then you explain what the complaint is. Or you can say it's the manner, and then we can have a debate. I just want to understand what's the nature of the complaint regarding that course invocation of those sections.
It is, well, I would use the word manner, but it is that the principles that govern how, what triggers the 186 and what triggers the 167 have not been correctly applied or not correctly applied, have not been brought into effect in this particular case, and have
been misapplied. Would that not be the correct way of saying it? You seem to be dancing around, trying to find words to avoid the misapplication of those principles. And that's what I'm struggling. So I am really trying to get you to explain it to me in a manner that I can be clear that you are not complaining of the misapplication of the act. It's more than that.
it is that there are the factual misapplication of a law is not the essence of the complaint on this aspect, in the sense that, no, she's wrong about X, should have done Y. It is, firstly, the rationale for engaging in this exercise is a particular rationale. The way in which this is triggered, in other words, the legal rationale for engaging in something has to be there, which in this instance I would submit is not there. The legal manner in which you are identifying the issues, which is the witnesses who are necessary for a particular outcome, you are not engaging those witnesses. The conclusions that you are drawing from those and the factual building blocks that you're using to make those, and the legal conclusions that you are ultimately drawing. That is now moving us beyond an exercise of the judge has done it one way, we would have thought it's going in a particular direction. It is that in the exercise of these principles, you've not applied the law correctly.
Thank you, Mr. Tisani. And apologies for calling you Mr. Shavang once again.
Okay, thank you, Mr. Tisani. The court will take a 20-minute break. Thank you.
Yeah, the two witnesses on this call those witnesses. As I said, my view is that with those allegations from accused one, she could not reject it purely on allegations, but she also couldn't rely on that evidence. So it was, in my view, she didn't have another option than to recall them.
You've had the debate we had with Mr. Tosini about whether our jurisdiction is engaged or not. And you have not said anything about that.
My apologies for that, yes.
Or do you stand by what you said in your head?
I stand with that, yes. If there are no legal questions to consider, and it's my submission that there are no, then I would submit that, yes, on that basis.
The inquiry about the jurisdiction of this court or the requirements can be very tricky. You must have heard when we were debating with Mr. Tosini that it can be a wild horse to ride.
Yes, yes. If there are aspects that involves the right of the applicant and in particular the right to a fair trial, I would submit that if any of those questions arise from this application, then that there would be jurisdiction. But in my view, there are no such questions.
So you also align yourself with the view that, which was expressed by my brother Nook there, that the court did not specifically make mention of the fact that it was applying the doctrine of recent possession, but everything was collapsed under the rubric of State versus Blom.
Yes, yes. She specifically applied the rules of evidence on circumstantial evidence, and if you work with circumstantial evidence, you have to make inferences from that evidence. In my view, she made the correct inferences. She had to make the inference whether the possession of the firearm was so recent enough than to make to find that he was in possession of that 2 weeks earlier.
Now, let me test this proposition with you. If the judge did not specifically say that she was applying the doctrine of recent possession, and the record indicates that she applied State versus Blom, is it possible to exclude the fact that in the application of Blom, State versus Blom, she did apply the doctrine of recent possession?
In my view, those are two different legal principles, and the principle of, or the doctrine of recent possession is not applicable in this instance.
But she didn't apply it?
In my view, no. purely relates to possession of a stolen item.
Yeah, but let's, she drew the inference. Was that the only reasonable inference that she ought to have drawn in the circumstances? I mean,
Yeah,
you have an incident that happened 10, 12 days later, and then you say, this the inference that I'm seeking to draw now, which is
Yes.
a reasonable one, based on circumstantial evidence, as you know it.
yeah.
You think that was correct?
She had to look at the evidence presented by the state, and she accepted that the applicant was in possession of
Well,
the firearm.
The possession is there,
Yeah,
but there is nothing that links the applicant with the offense that occurred 13 days later.
I 100% agree with that, Justice.
Would that have been the only reasonable inference to be drawn in the circumstances?
Justice, she also had to look, and she mentioned it in the judgment, that she had to take into consideration the fact that the applicant remained silent.
Doesn't have to say anything. You and I know.
Yeah, it's 100%. I agree with that.
Walked out of court, nothing would have happened.
Yeah,
So it's not a fact.
yeah.
What was that?
There are, however, case law that says silence in the face of evidence implicating you can strengthen the state's
Yeah,
case.
what was the evidence implicating?
Yeah, it is different than in this matter.
So now it comes to my point that I raised with your colleague about the risk of an unsound conviction. Would a risk, if the applicant has been subjected to an unsound conviction, would that impact on his right to fair trial? And would that also amount to a failure of justice?
I would submit yes.
Why? Why is that? You're not going to submit. Why you say that?
If the incorrect inference was drawn, it directly impacts his guilt in this matter. I don't know if I understood the question.
I don't understand you.
Yeah, I apologize.
I'm saying, here is the appellant, Mr. Shabangu, who is incarcerated on the basis of what appears to be an unsound conviction. You may have a different view about that. If one has to serve or be incarcerated, serve a prison term, on the basis that you are there, on the basis that the conviction is suspect, is unsound, is that not a failure of justice?
It surely is, yes.
And if it's a failure of justice, it means the applicant's constitutional rights are infringed?
Yes, no, definitely.
If they are infringed, would that engage our jurisdiction?
Yes, I would agree with that.
And if you agree that this would engage our jurisdiction, then we'd find jurisdiction and say the conviction is unsound, and should we set it aside?
Yes, no, I would submit so.
In other words, your submission is that the applicant must walk.
No, it's not my argument.
No, but I'm testing the proposition with you.
Yeah. As I argued, in my view, the judgment is sound and correct, based on the law she applied.
Okay. All right. Thank you.
Thank you, Justice.
Mr. Maritz, I want to refer you to page 193 of the judgment, lines 15 to 25, where Judge Satchwell remarked as follows. Do you have it in front of you?
193.
Correct.
Yes.
I've been most concerned regarding the identity of the firearm. I was not satisfied and did not believe the state had proven that the firearm found by Inspector Posa in the possession of accused 3 was necessarily the firearm subject to the tests in Pretoria and dealt with in Exhibit E. This concern deepened after I heard the address of accused 1. Accused 1 referred to documents which had not been handed in as evidence to the court. He averred that these documents had been tampered with. He averred that these documents had been amended. So after the close of the state case, the judge, from her own mouth, says that I didn't believe the state had proven its case. My question to you is, when there's no evidence against an accused, is the court entitled to exercise a discretion and call witnesses at that juncture? Or must there be a threshold? Must it be clarification, or can a judge call witnesses to effectively prove the state's case?
I would submit, Madam Justice, if this case ran its normal course, she would not have been entitled to call witnesses.
So what was the distinguishing feature here? Why do you say she was forced?
It's maybe not the correct word to use, but she couldn't rely on the evidence.
And then what's the consequence of that? An acquittal, not so?
Yeah, it is, but unfortunately...
That's the way our system is designed.
Yeah, no, I agree with that, yes.
Then, my question to you relates to the argument advanced, which was not argued, but assuming that one were to find substantially in favor of the applicant, is there any scope to convict on the possession of the firearm for an unknown caliber of caliber of a gun which we don't know whether it's 7.65 millimeter or 9 millimeter, but what's clearly not in dispute is that he was lying in the reeds on top of something that looked like a gun.
Yes. Madam Justice, the applicant has, as I gathered, or rather have information about in the rest of the record pertaining to sentence, that he was convicted of possession of that firearm, as well as another count. So unfortunately, that information of his possession of that firearm was not placed before the court hearing this matter. And in my view, that he was already convicted. The principle of outrefus convict applies with regard to the firearm specifically.
So I just want to explore two issues with you. The one is, if one assumes that there is no evidence before us on the caliber of the gun, can one nonetheless convict and give, say, the minimum sentence for unknown caliber? Is there any scope for that? That's the one question. And perhaps I should stop there, let you answer that.
The problem is that the state has to prove beyond reasonable doubt that the object found in your possession is a firearm as described in the Firearms Act. And for that, firearms are sent for ballistic testing and to confirm that aspect. So you would need to make a finding that that firearm was indeed a firearm capable of firing certain rounds. Yeah, that's.
All right, so your answer is there cannot be a conviction. But I want to ask the second question, which actually becomes academic, but I want to ask you nonetheless. And this is the issue of, or the concession in relation to the fact the atrophy convict argument.
Yes.
I mean, is it correct conceptually to say that once you've been convicted of being in possession of an unlicensed firearm, you can't again be convicted of possession of the same firearm on another day? Because it's a bit like being caught without a license with your car. You can't say, well, I've now been fined. You must now legitimize your position.
Yeah.
So isn't it a new offence? And I know the argument that advanced in the heads of argument for the applicant is that it's a continuous offence, like theft. But I take issue with that proposition. I think you can commit it this morning and you can commit it this afternoon, and every time you must purge your non-compliance with the statute. And until such time as you've remedied that, you can be convicted as many times as you've found with it. Not so.
Yeah, my submission is that he was found in possession of that firearm on the day of his arrest, and he should only have been, he was convicted of that possession. So in my view, only that conviction.
So he was convicted of that day?
Yes.
Previously?
On the Morocco police case, as I can state it, yes.
We don't know that from the papers?
It doesn't appear from the papers. The sentence aspect was not initially part of the directions, but it is available in his previous convictions that was placed before the trial court.
What do you say about the fact that the court identified 5 witnesses and only called 2 of them?
The court initially appears to be of the view that the investigation would have entailed calling all those witnesses. But my submission would be that as she started to investigate it, she was satisfied that there were no substance to that allegations, and that it was not necessary to call the other witnesses mentioned.
Thank you.
Mr. Maritz, just one question on the reference to the judgment at page 193. The amicus, that is when the court invoked section 186 to recall the witnesses. The amicus argued that the trial court, acknowledged the evidentiary gap and used the judicial intervention to fill that gap. And that affects the fairness of the process. What do you say to this submission?
Madam Justice, if that was purely to assist the state, I would have agreed with that submission, but we are dealing with a different scenario in this case, where the court had to act on the allegations by accused number 1 in his address. I can't take that argument further, unfortunately.
And besides the possession of the firearm, that is the inferential reasoning that was made by the court, there was no other evidence.
I agree with that, yes. There were no other evidence. It's the only evidence.
Do you know of any case where a court, assuming what the court did was applying the doctrine of recent possession, where a court that did that in a situation involving a firearm, a murder weapon, as opposed to normally it's used for stolen items?
Unfortunately, I can't think right now, my lady. Justice. Madam Justice.
Thank you. Thank you, Mr. Chair.
Thank you very much.
Simarit, I just want to understand your position in relation to the unlawful possession of firearm and ammunition. What do you want this court to do anything about that? Or what? Because it seems as if that issue was not properly dealt with in the High Court.
If a reading of the record, if I read it, I would. There was Madam Justice Satchwell invited, in particular, the defense of the applicant to provide that information, but it wasn't forthcoming. So she did not have, she couldn't arrive at any other conclusion than to convict in the absence of those information, and the applicant also did not plead that special plea of outre force convict.
So in your view, is that something that this court should do something about or not? That's all I really want to know. And from...
I would submit that the possession of the firearm and possession of the ammunition is on different footing, because the applicant was only convicted of possession of firearm in the Morocco case.
And that's not before us?
That's not before the court, yes.
I'm asking about the possession in relation to this matter.
In relation,
he was also convicted of unlawful.
He was convicted of unlawful possession of the firearm, yes. Based on the inference that was drawn that he was in possession of that firearm on the day of the incidences in this matter.
No, I ask this question because sometimes I hear you as if you are acknowledging that he was indeed convicted in relation to the other one and should not have been convicted. So I just want to be clear what exactly you want this court to do about the conviction, those convictions in relation to this matter.
My submission is on the conviction on the firearm, that he was previously convicted of possession of that firearm, and that he should not have been convicted on it.
And so we can take it as a formal concession that that conviction cannot, should not be confirmed.
I would concede on that, not on the possession of the ammunition, because he was not previously charged and convicted on that.
Only the ammunition?
Only the, yeah.
Sorry.
Only the firearm, yes.
Okay. Thank you.
Thank you very much, Mr. Maritz.
Let's go, please.
Thank you. Mr. Mpaga.
As the court pleases, Deputy Chief Justice
you.
Malambo and Justices. The amici, Deputy Chief Justice and Justices was responding to an invitation from this court to address the question whether the trial court correctly applied the doctrine of recent possession and to deal with condonation. And I think the applicant has already dealt with condonation. I don't think it's worth revisiting it. So I note from the comments of the justices that it looks like this invitation in a way should have read differently. But I take it, having listened to the justices debating this matter, that maybe the doctrine was not directly mentioned in the judgment. Therefore, it not being mentioned, then it should be accepted that the court did not rely on it. But having considered the judgment and also having looked at the prerequisite of the doctrine of recent possession, we have the view that it would appear from the judgment that that doctrine was applied. And we have referred in our case to State versus Paro, where the court, the appellate division then said that the doctrine of recent possession permits the court to convict an accused found in possession of recently stolen property in the absence of an innocent explanation, but only if the prerequisite for recent possession and the test for the acceptance of circumstantial evidence are also met. So it looks like there's a hybrid there in that doctrine. It means, firstly, there has to be prerequisite for the recent possession, and also there has to be the test that has to be applied. Then I would submit that if you look at that, then it means that the Blom will apply. Blom will apply in the doctrine of recent possession because it's not, you not look at it in isolation. So, and this is also confirmed in the judgment in State versus Motwa, the SCA judgment, where the court defining the scope and prerequisite inquiries for the doctrine of recent possession stated, the doctrine of recent possession permits the court to make the inference that the possessor of the property had knowledge that the property was obtained in the commission of an offense, and in certain instances was also a party to the initial offense. So looking at those elements, therefore, we submit that there has to be possession. And in this instance, the appellant was found in possession of the firearm. And the second aspect is that the property was recently used, in this case, in the commission of offenses. So we submit then that if you look at those two elements, the court makes reference in the judgment several times to say that it relied firstly on the fact that there was possession at the time when he was arrested, and you utilize that possession to find him guilty for possession at the date of the commission of the murder, robbery, and possession of firearm. So we submit that the findings of the court in this case, justices, is that the elements of doctrine of recent possession are clearly implicit or explicit in the judgment. And simply as a matter of reference, on page, the other aspect which is important as it appears from the elements which are being propounded by the appellate division or the SCA is that there has to be an innocent explanation. And the court has dealt with all those elements. The court firstly has dealt with the question that the applicant was found in possession. The applicant could not provide a reasonable explanation. He exercised his right to silence. And the fact of the matter is that the court then drew an inference. So the inferential reasoning, which is in Blom's case, has to be applied when you apply the doctrine. So we want to submit that on the reading of this judgment, the court did not have to explicitly say that it relied on the doctrine, but where the elements of the doctrine are clearly set out in the judgment itself, we submit that in this case, then the court quite clearly relied on the doctrine without having stated the fact. And then the question becomes that, as the court properly indicated, that in this case, the court says that the appellant was found in possession within 2 weeks. So the whole issue of duration is very important in the doctrine, because duration clearly is important for the court to establish or draw inferences as to whether it can rely on the duration to draw an inference that the accused committed the offenses that he is charged of. And what is important also that one finds in the judgment on page 201, I think line 10, and where the court says, I could of course speculate. I could speculate that accused 3 acquired this firearm from another person. Perhaps he acquired this firearm after the 28th of April, but that would be speculation on my part. I would be making up that story, and that is not appropriate for a court to do. So those are probabilities that the court was alive to, that it would have been probable during this period of 2 weeks that the appellant could have acquired the firearm from somewhere. So one cannot simply draw an adverse inference from his silence, but one must look at the probabilities that would have happened. And I think in the Square judgment that we are also referring to, the Square judgment, say this Square is, I think it's an appellate judgment, the Supreme Court of Appeal, where it says, confirm the following critical qualification of the doctrine of recent possession. Namely, it is the requirement that goods must have been recently stolen. So the issue of the possession being recent is quite clear from the judgment. The nature of the stolen article is an important element in the determination of what is recent. And if the article stolen is of the type which is usually and can easily and rapidly be disposed of, anything beyond a relatively short period will usually not be recent. Is the article one which could easily pass from hand to hand, and was the lapse of time so short as to lead to the probability that this particular article has not yet passed out of the hands of the original thief? So, reference in this judgment on page 201 to the court was alive to the fact that the nature of the item, being the firearm, it was possible that it could change hands because of the nature of the item. So we would submit, if one looks at all the elements that are supposed to be there in the doctrine of recent possession, so are they also be clearly referred to in this judgment? And we therefore submit that Blom must not be looked into in isolation, but Blom is part and parcel or forms part of the consideration of the doctrine. So in applying Blom, the court had already pointed out very important elements of possession and the period. And after that, then it applied Blom, whether it is the only reasonable inference to be drawn from the facts. And I would submit that when one looks at the facts of the case, clearly we submit that the problem about applying the doctrine in respect of a firearm is, unlike in the case of stolen goods, is that with stolen goods you can give a reasonable explanation of possession. But with it comes to firearms, it is especially an unlicensed firearm. Already you are guilty of being in possession of an unlicensed firearm. So there's a distinction between the two. But would submit that the very fact that the appellant in this matter exercised his right of silence can be gleaned from the fact that, as at the end of the state case, there was no case which was established on a balance, beyond reasonable doubt by the state. And it is quite concerning, as one would have seen in the judgment, where the court tried by all means to forewarn the state in terms of the gaps that were there in respect of the evidence that has been laid. But the prosecution clearly says that we are satisfied. I am satisfied with what I have. And then when the accused number one in his address made references to documents, which documents then triggered the court to exercise Section 186. And I would want to agree with Justice Opperman in respect of the fact that the exercise of the 186 discretion And the court in that inquiry makes reference to the material witnesses who are 5 witnesses, material witnesses, and it only calls 2 of those witnesses. But one must inquire as to why it was important for 5 witnesses to be called in the excess of that discretion. The 5 witnesses were supposed to be called because if you look at the documentation that was being utilized to lead evidence, there were challenges in respect of inscriptions that were made in respect of the type of the firearm. And there were particular persons who made those inscriptions. And the other aspect, which is very important, is that you have 2 offenses which are committed here. The first one is in respect of the murder. The second one is in respect of the hijacking or the robbery. Now, this firearm was first taken out for testing in respect of the robbery of the ESCOM vehicle. And it was then brought back. But what is critical when you look at the chain of custody, and I think the 3 witnesses who were not called were very critical in respect of the chain of custody. Because if you can look in the record, Justices, you will never find evidence on who received the firearm when it was first taken for ballistic test. When it came back, there is no evidence as to who received it. So those 3 witnesses were material in the court exercising that discretion in terms of 186. So its legal conclusions arising from that inquiry, I would submit that it's lacking. And when you exercise the Blom principle now in respect of this doctrine, one would submit that without those 3 witnesses who were not called, the chain of custody is broken. Because you need to be able to say that the firearm that came from the robbery scene, the second robbery scene, that went into the SAP-13, that is accounted for. That firearm, when it left the SAP-13 and went to ballistics, that is accounted for. But there is no account in respect of that firearm coming back from ballistics and being received into the SAP-13 by the police. So there is that chain of custody which is broken. And one would submit that on the probabilities, one would say that the court could not say that the only reasonable inference to be drawn is that what was found on the accused person was the firearm in issue. So one would submit that I was just looking into section 12.1 of the Constitution, where it says that everyone has the right to freedom and security of person, which includes the right not to be deprived of freedom without just cause. And I would submit that it consolidates to what Justice Matopo is saying, that clearly the whole matter invokes some sense of injustice, that the court must be able to say that, but can we deprive the appellant of his freedom wherein it is quite apparent that something is missing? We have a situation where the appellant exercised his right to silence properly after the close of this case. Initially, he wanted to apply for section 174, but then they closed the case because at that time, there was no case to answer. But then when this exercise of discretion to call witnesses, if the court exercises that discretion, it must ensure that that discretion that it exercises is fair. And want to submit that it was not fair in this instance because the only witnesses who were called were those witnesses who had earlier testified about the discrepancy in terms of the firearms. And one has to look at Poswa's evidence to say, he says, I realized immediately after I have testified that I might have been wrong about the firearm. But why does he not come back immediately? He waits until the court invites him to come and rectify. So if he had a sense of justice at the time, he should have been able to respond immediately and say to the prosecutor, can you recall me? I think I made a mistake about the firearm. He doesn't do so. He says immediately after court, he realizes that his testimony was not correct, but he does not exercise that right. He waits for the court to invite him. But what is of importance is not only the evidence that was tendered by these 2 witnesses, it is the documentation that the court had to rely on in order to close the gaps in terms of the chain of custody. And we are saying that those 3 witnesses were material witnesses and they were supposed to have been called. As the court pleases. Chair.
I see the bell rang as you were getting into full force with your submissions. Sorry.
Mr. Mpaga, I'm just not sure about the submission that a conviction based on circumstantial evidence that kind of reasoning is part of the doctrine of recent possession. I'll tell you what, because a conviction on circumstantial evidence, in my understanding, inquires as to whether the circumstantial evidence on its own meets the standard of beyond reasonable doubt. You understand what I mean?
Yes.
It does not call upon the accused person to give an explanation, as the doctrine of recent possession does. So it seems to me those principles, for lack of a better word, are a bit distinguishable from each other. And if the court was minded to apply or to use the circumstantial evidence route, it seems to me that it was not allowed to say that an inquiry into other probable inferences that could be drawn was speculation. You understand what I'm trying to say? It seems to me that it either applied the principle incorrectly or extended the boundaries of that kind of reasoning that is based on circumstantial evidence.
That is so, Justice Dambuza. Yes, I was simply making just a comparison because in respect of the doctrine of recent possession, it appears that an explanation is sought. And the court now having made a finding here that there was no explanation. So meaning that it required the appellant to have made an explanation in respect of his possession. And in this instance, I see similarities between the elements of the doctrine as I've referred to in Molojwa, to say that you need to have a hybrid. You need to have the elements in terms of the doctrine, the use, and also the circumstantial evidence, the test has to be applied.
But I'm not, now, the part that I'm not certain about, and that I need your assistance with, is whether then do we say the court misapplied the principles set out in Bloom, or it extended them in its interpretation of the principles set out in R versus Bloom.
So our argument was that it extended the principle of the doctrine in respect of possession of firearms. That is our argument. That if one looks
Which is an interpretative exercise,
yes,
in other words.
It's an interpretative exercise from if one looks at references that are made by the court.
Yeah.
So that is our argument.
Why is it not application?
Why it's not?
Why is it not?
We are saying that applying it here, when you apply it in terms of theft, then it is easy because the theft is a continuing offense. So one is found in possession of goods. At least at that time, you can be able to explain that I bought them, and then you can be able to prove also with a receipt. But the firearm is a very difficult thing because if it's unlicensed, it's unlicensed. You've got no explanation to make. You are guilty of possession. So I thought that applying it in terms of a firearm, it's a bit taking it too far, whilst applying it in terms of theft, and it's easier.
Well, the court says, look, if I look for other explanations, I will be speculating, and I'm not entitled to speculate.
And that speculation arises from the fact that there is no innocent explanation. And that's what forces the court to speculate. In the same sense, when you apply the doctrine to theft, if you don't explain possession, then you allow the court to speculate as to whether these goods were stolen or not.
Or then, if the court sort of got confused and conflated the two routes of reaching the conclusion, what is that? Is that interpretation or simply misapplying both principles of reasoning?
Yeah, I would say that it is misapplying the principles and the reasoning in respect of the principles.
If it conflated,
If it conflated both principles.
then if it conflated them, then the court doesn't have jurisdiction.
Our submission,
Putting aside for a moment the fairness argument.
yeah, the issue is that we are saying it's a principle, a doctrine that was applied and misapplied in respect of the facts of this case. So in that respect, we say the court, in applying this doctrine, basically erred and should have applied it in respect of a firearm.
Thanks.
Okay.
Mr. Mpaka, I drew your colleague's attention to the judgment in Tuta, which dealt with an error of law, which grounded our jurisdiction. Would you say what transpired in this case amount to an error of law? And if so, what is that error of law?
I would say that the error of law arises in the inferences drawn in terms of the Section 186, because the court relied on the Section 186, but we submit that if it relies on 186 and applies a discretion, then in that instance, it was supposed to have gone further if identifying the material witnesses who were crucial in respect of closing the gap, in respect of the custody of the firearm. And it doesn't call those witnesses. It does not even explain why those witnesses were not called, if they were considered to have been material. And we want to submit that one can confine that into an error of law.
Well, following the debate my sister Opperman had, if the court is of the view that there is no evidence upon which it can convict, and the court thereafter decides mero motu to invoke the provisions of 186 to call for evidence in supplementation, it's that permissible in law?
Yeah, we submit that it is impermissible, and at the time when the prosecution itself, after having been forewarned, it said to the court that I am satisfied, despite the discrepancies. And the court itself having indicated that on the evidence that what was tendered by the witnesses in respect of the firearms, it could not convict at the time when the case was closed. I would submit that for it then to utilize Section 186 and bring the evidence in terms of 186 through the back door, I think that in itself also constitutes an error of law.
That tells us if an error of law results in an unsound conviction, this court is entitled to intervene.
I would submit, yes, that this court is entitled to intervene, as this whole exercise of 186 being used in this way, quite clearly it appears to be a novel issue, because where all parties are satisfied that the case has been closed, and it is only during the address by accused number one that the court then is triggered to invoke 186. I would submit that for it to trigger this, to utilize 186, to then assist the state in proving its case, I would submit that that in itself clearly, in my view, constitutes some form of overreach.
Well, let's look at the principle that you are seeking that we should establish. is the submission that this court should establish a principle that says if there is no case that has been proved by the state, a court is precluded from calling for additional evidence. I just want to, because I'm not thinking about this case. I'm just thinking now about the lower courts, what this judgment would convey.
I would submit that that nothing prevents the court to seek clarification questions in respect of the evidence that has been tendered or to call witnesses to testify on his behalf. But where the state itself says it was satisfied with the evidence and the court had forewarned it that your case is in the air and continues to close that case. Now for the court to then usurp the functions of the state.
Thanks, I understand now.
Yes.
Thank you, DC Chair.
Okay, thank you very much, Advocate Mpaka.
Thank you. Thank you, Judge.
Do you have a reply, Mr. Tisani?
May it please you, Deputy Chief Justice. My reply is not going to require the full 10 minutes. It's just two very narrow issues that emerged from...
Yeah, just try and speak to the mic and that's what we can hear you.
Yes,
Thank you.
my apologies. My Deputy Chief Justice, my reply will not take long. It is narrowly focused on two aspects that emerged from the respondent. The first issue pertains to the question of the 186 and the section 167 witnesses, and in particular the circumstances under which, having identified an issue, the court then proceeds not to call those particular witnesses. Now, Justices, this was a matter that was specifically dealt with, and it is in, of course, the heads of argument, but it was dealt with under the Director of Public Prosecutions, Transvaal v. Mtsweni. And in the Mtsweni matter, it was dealt with specifically in the instance where a court had called a witness, identified that a particular witness was necessary, but then proceeded to fail to call that witness. And the observation made by the Supreme Court of Appeal then, per paragraph 24 of that, is that where a court itself decides that it's going to invoke these proceedings, it's going to invoke this process, it identifies a particular witness who's going to speak to it, it identifies that witness as being essential to it, and then proceeds not to, in fact, call that witness. That is an irregularity. And not only is that an irregularity, that's an irregularity that amounts to an error of law. And that is, even if, as was the case in Mtsweni, the court's view is that ultimately, well, or that witness didn't ultimately prove to be material, or that witness wasn't ultimately required. The mere fact that the court has itself identified a particular witness as being essential obliges the court to then answer that question. And I would submit in this regard, that's critical, because we have a number of witnesses who have been identified. The court has itself identified these witnesses. It's the one that has entered into the process and said, well, I'm invoking these provisions because this is absolutely essential for these questions to be asked. And as the amicus has correctly pointed out, these are not mild issues. They are issues that go to the very chain of custody of what you are discussing. And then you don't call those witnesses. That is not a misapplication of the law. That is, having invoked this process and then not following it to its logical contention, that is an irregularity in the proceedings. And I would submit, if one then has regards to that, that is precisely the difficulty we have with the Section 1, use of the Section 186 and the use of the Section 167. You've opened up a Pandora's box of questions, and you've then declined to answer those questions. Courts have a discretion to invoke the proceedings of 186 and the discretion to invoke the proceedings of 167. But they only have the discretion to do so in circumstances, one, where they are indicated, and two, having invoked them in circumstances that they are indicated, they are then obliged to follow the processes and the principles that accord with having so done. And in this instance, by failing to do so, we are now left with a conundrum, because it is in the midst of that decision, or rather in the midst of that process to arrive at a identification of a particular firearm, that it then formulates and becomes the only basis to then establish that somebody is in possession. And that then brings me to the second issue, which is the one of where is the crossover point between inferential reasoning and the doctrine of recent possession. And Madam Justice Tambuza has taken both myself and Mr. Mpacha through where are the parameters of that, where does one find it? We would submit that the formulation of the doctrine of recent possession is that there are two legs to it. One is that you have to use reasoning that would be inferential in nature, in accordance with the principles of inferential reasoning. And then over above it, one would then apply that if something is recently in your possession and it is found to be in your possession, those two processes then come together. It's, I would submit, not one where it's entirely severable. They are, in many instances, common components. But there's one very distinct difference. If you are going to be using a process of pure inferential reasoning, the very essence of inferential reasoning is that there are objective sets on which you are drawing those inferences. Otherwise, you are engaging in a process of speculation and conjecture. In this instance, you almost have a circular argument that you are found in possession of a murder weapon on a particular day. Therefore, you must be in possession of that weapon on 13 days earlier. And I would submit that if one then follows the need to have form over substance, the judgment in Mutua, I beg your lordship's pardon, is very particular in one very important observation. It permits a court to take the inference that the possessor of the property had knowledge that the property was obtained in the commission of offense, and in certain circumstances also was a party to the initial offense. Now, one doesn't want to be facetious, but if it looks like a duck, it quacks like a duck, it's a duck. The court has not used the specific words, I'm applying the doctrine of recent possession to the sex. But everything that has taken place is as the doctrine of recent possession is stated. And I would submit in that regard, if one has regards to substance over form, one is indeed dealing with a court that is applying the doctrine of recent possession and including circumstantial elements to it as they are obliged to do. And therein fundamentally is the problem. Because once we accept, as we submit, that that is indeed the case, then you are indeed developing the doctrine in an unusual way. Because then you are no longer applying the doctrine to recently stolen items. You are, in fact, applying the doctrine to a murder weapon. And that, we would submit, is now a development of the law, and it, in fact, is a legal question in that regard. Those are my submissions in reply.
Thank you very much, Mr. Tisani. Thank you very much. The court appreciates the assistance it has received from counsel. In particular, Advocate Mpaha, on Tuesday, I conveyed a message of appreciation to members of your group to convey to you. I repeat those words of appreciation to your society for always being available and prepared to assist this court when we require assistance in terms of submissions. So thank you very much for that. Judgment in this matter is reserved. Court adjourned.